Hello.
Hello.
Good morning.
Yes, sir. Good morning.
Good morning.
Morning, sir.
Good morning, sir. Good morning. Good morning to all of you. And you able to
Good morning.
you able to see? Good morning. You able to see the screen?
Yes, sir. We can.
Okay, good. So good morning. Today is the sixth session. Some vibration is coming. It's coming just a minute. Okay. Okay. So good morning to the today's session. We have completed 5 sessions, and today is the sixth session. So let us start today's session. We will discuss today in this session mostly about the service exports, and then of course refund of the service exports, and free trade agreements we will discuss, trade and tariff and non-tariff barriers, then new rules of origin, CAROTAR 2020, that is also I'll be brief. Then international logistics related, we'll make some Incoterms of course we have discussed, but more case studies we'll discuss here. Not exactly in Incoterms again, but some case studies we'll discuss so that you can understand the importance of Incoterms and how to go about. And also the port and shipping formalities about the containers and how to select the container types of containers, all these things we'll discuss. Okay. So this is how today's session. First, going towards the service, what is meant by service? Because whenever we are talking about service in India, when immediately the GST comes into picture, because that is the only law now, because service tax and other things not available now. Only law for in India now is GST, other than of course indirect tax, customs and other things. Okay. So whenever we are talking of the service, this is well defined in GST. So we refer the GST provisions as per the section 2 of 102 of CGST Act. Service means anything other than goods, money and securities. Very simple they means here the definition is like this. Like for example, you ask who is a female, then other than man is a female. So that is like definition here. Okay. So other than goods, money and securities, all are services. Okay. So again, service is a broad term, and some of the features we discuss here: export of services, similarly import of services also we discuss, and what is the liabilities of the taxes, that is also we will understand. The export of service, they defined, there are 5 conditions they mentioned. 5 conditions they mentioned in section 2.6 of export of services in IGST Act, okay, 2017. Here, first condition is the supplier of the services must be located in India, because we are talking from India to export outside India. So therefore, the supplier of the services is located in India. That is one condition. The second condition is the recipient of the services is located outside India. It looks a little bit common sense only, because we are making the export of services. The service provider must be in India and service recipient must be outside India. These two are very common sensual. Now the third one they talk about the place of means place of supply of services outside India. This is where the criticality comes. Then you have to understand about the place of supply also. What is the place of supply definitions in terms of the GST, so that we have to understand. So this created certain confusion, certain more complexities. Then third one is payment related. Of course, payment related, it should be, because we are talking about export, so that it must be in convertible foreign currency, foreign exchange. But in some cases, Indian rupees also allowed as per the RBI guidelines which are provided. Okay, so this is how the about the payment. Then the fifth condition. The fifth condition, again a lot of confusions created and lot of difficulties also people have faced in the early stages of the introduction of the GST. But later, of course, these cases are settled down. Many of the ARs also there, advanced rulings are there. So through that advanced rulings, something is very clear now. But initial stages, it is created also a lot of issues and problems and confusion over the matter, because suppose in India you are the service provider and your own office is there, for example in overseas, or representative office or some license office or whatever may be. Then from India to your license office or your commission office, if anything is there, if you are sending these services, then whether it is treated as export or not, there was a confusion. But later the confusions are removed through various clarifications and various circulars also. So that is what the settled law. Now these are the five conditions are there. These five conditions all are has to be fulfilled, then only it is treated as an export of services, otherwise no. If any of the condition is not fulfilled, then it will not be treated as an export. Okay, so all the five conditions to be fulfilled. Some of the cases also will discuss. Each of the issue we will discuss some cases, right? So satisfy all the five conditions. Okay, now case one, for example, we will discuss the supply of the service to a person located outside India where the place of supply is in India. Means some example like we will say Indian supplier, that service provider is in India and he got an order from overseas recipient, service recipient, then asking the Indian suppliers to make the delivery of the services within India. Actual service provided in India. Then whether this is treated as a export of service or not. And of course, you got the payment receipt also in foreign currency. Means you are the service provider in India and you got an order from overseas service recipient, and if you fulfill the services, he will make the payment in foreign exchange, foreign currency. So he has made the foreign currency payment. Then whether this satisfies that this is an export of service or not. Any idea?
Yes, it is an export of service only, sir.
This is treated in export of service. Okay. Okay.
Because
Okay.
we'll bill to outside India.
You bill
So
to
the
outside India.
foreign ship to India. So that's why it is treated as a intra company. I mean to say it is a export of service.
Export of service. Okay. Okay. So just now I told you we have to satisfy all the five conditions. Here one condition is the service provider must be in India. Yes, he is in India. The recipient of the services must be outside India. Yes, he is outside India. These two conditions satisfied. The place of supply must be in India. But where is the place of supply? Place of supply happen in India because actual services are provided in India. Therefore, it is not export. Because place of service also must be outside India, then only it will be treated as a export of services, otherwise no. So the third condition, out of those five conditions, the third condition is not fulfilled. Therefore, this is not export of services. So that is a lot of confusions are there on export of services. we feel whenever we are receiving the payments in foreign currency, we think that it is an export, but no. You may receive the payment in foreign currency, consideration can be received in foreign currency or Indian currency, but the thing is that all the 5 conditions if satisfied, then only it is treated. Here in this case, the place of supply happens to be in India, therefore it is not export of services, not treated in export of services, as the place of servicing is in India. Example, Indian property owner renting a property in India to an overseas customer. Suppose the overseas customer, he want to start an office in India, for example, and India he has started an office on rental basis. The service provider, mean Indian property owner, he has given the premises for the rent in India only to the overseas client, and he pays the payment also in foreign currency. Even then it is not treated as a export of services because the place of supply is in India. Similarly, providing the services of an organizing a function or event in India for overseas recipients. Overseas means, for example, a person from Dubai, he want to celebrate a function in India, and for that he has taken some premises like a function hall, for example, he has taken, or he has booked in a hotel certain space he has booked, and he want to celebrate in India, but he is from the UAE, from Dubai, for example. He is making the payment also in foreign currency, but that is not treated in an export of services. Okay. Similarly, one more example I will tell you. The Indian architect is there. He is an Indian architect. For example, Indian supplier is an Indian architect, and he has been contacted by some overseas, for example, from here. Again, you can say it is from Dubai, because from Dubai, a lot of investors are there. They are investing in India. Suppose he want to, the person from the Dubai, he want to put up a hotel in India. For that, he want the architectural services from Indian architect. A person in Dubai, he want to invest in India, for which a hotel he want to construct, for example. So for that, he want the services of a architect in India, means Indian architect he has contacted. Then Indian architect is provided the services, because that services is in India, that provision of the architectural services for the hotel in India. So therefore the place of supply is in India, though the recipient of the supply is in outside India, but the services are provided in India, therefore it is not export of services. Okay. Similarly, many other examples I have given here. So this is one of the case, and some other cases also we'll understand, so that from this we can be very clear about what are the services treated in export of services and which are not. In many cases it looks like it is an export of services, but if not satisfy all the 5 conditions, then it will not be treated in an export of services. So next, again we'll take another case. Indian service supplier of Indian services in India only, he has provided services, and the recipient also in India. The supplier of the services in India, the recipient also in India, but the services, the place of service is outside India. For example, a investor in India, he want to make investment in, for example, in UK. For that, he want Indian chartered accountant services for establishment of the office in UK. Means Indian chartered accountant, he has provided the services to again Indian recipient, but the services for outside India for establishing the office in UK. Here also you see all the 5 terms are being not fulfilled because the recipient of the services is in India. Second condition is not fulfilled. Therefore, in this case also, though you are making the payment in foreign currency, foreign exchange, even then it is not treated as a service export because the second condition is not satisfied. Example, engineering and architectural services or education and training services are the Indian agent or consulting firm engaged in Indian service providers and delivering the services overseas. So these cases also will not be treated as a export of services, even though we are receiving the payment in foreign currency. Generally, our misconception is whenever we receive the payment in foreign currency, we feel it is an export, but it's not so. Clear, sir? Then the other third case, Indian recipient of services, he has placed an order for the overseas supplier. The supplier is outside India, overseas supplier of services, asking him to provide services to overseas client. The Indian recipient of services mean Indian, he got a client in overseas, for example. For example, in Dubai, he got a client, and that Dubai client required certain services. For that, what you made it, you have engaged a other person from UK and asked him to deliver the services to the Dubai person. The Indian businessman got an order from Dubai, a service order, for example, software development. The Indian businessman got the order from the Dubai for the service software service, and for that, the Indian businessman engaged a UK-based a software company, asking them to develop the services, that software, and deliver to the UAE, means in Dubai. In such case, of course, you may receive the payment in foreign exchange, but this type of services is not treated in export because the conditions are the Indian recipient must be in the Indian recipient, the supplier must be in India. The first condition, the supplier of the services must be in India, but in this case, the supplier happens to be overseas. So therefore, it is not happen to be first condition is not satisfied. Therefore, this is also not a case of export. The other condition, Indian supplier of the services, he got a service order from the overseas recipient, and payment, of course, in Indian currency. For example, here he receives payment in Indian currency. In such case, the fourth condition, that is, the payment must be received in foreign convertible currency. So that is not satisfied. In such case, it is not treated, even though the services are provided outside India, but payments are received in Indian currency. This case, except in certain few cases, as per the RBI guidelines, for example, Nepal and Bhutan, some services we can provide that you are receiving, then it may be treated as the export of services. Otherwise, no. Because in all other cases, we have to receive the payment in convertible foreign currency only. Therefore, that is not treated. So this is not a export of services. And another case, Indian supplier of services and overseas recipient, he has placed an order, and payment also he releases in foreign convertible currency. Supplier and recipient are distinct persons. For example, you have a businessman, you have an office in India, and you have a license office in overseas. For example, in Dubai, for example, you have an overseas office. You have sent certain software or other services to the overseas office, and for that, of course, from the overseas office you receive the payment, that branch payment or whatever it may be, your own organizations, you maybe receive the payment in foreign convertible currency. These two people are treated as a distinct persons as per the GST. So whenever the transaction happens between the two distinct persons, though the other person means the conditions, other conditions satisfied, means first condition satisfied, that a service provider is in India, the service recipient is outside India, the place of supply is outside India, three conditions satisfied. The fourth condition also, the foreign currency receipt of the payment is also satisfied, means all the four conditions are satisfied. But the fifth condition is they should not be, means distinct persons. When it is becoming distinct persons, then that fifth condition not satisfied, therefore it will not be treated as an export of services. Okay, clear? Whether software is regarded as a goods or services, there is a lot of controversies also there. So not only now, even in earlier, before the GST regime also, this controversy was there. Certain times the software is treated as a goods, and in certain cases it is treated as a services. Therefore, in earlier cases, lot of litigations happen. The litigation is, if it is services, earlier cases before GST, service tax is applicable. If it is goods and transaction happen within the state, then VAT is applicable. VAT is a state subject, and there lot of litigations happen. The state departments, they used to demand they must be pay the VAT, otherwise they started issuing the notices. On the other hand, the central departments, service tax is central department, they used to issue the notices. If the service tax is not paid, then the software, one thing can't be in two, like one is goods and services, both it can't be simultaneously. Both one item maybe, yeah, means yeah, it can't be both service and both yes, again a product or goods. So therefore there is controversies are there. Both the departments are starting issuing the notices for the same transaction. Central departments used to say that this is the service, and state government department says that this is the goods. So that controversy was yes, going on. Though there is a Supreme Court judgment also there on this matter, but a lot of confusions are there. If any standard items, pre-developed, pre-designed softwares are developed and sold, like something is, for example, a game is sold in a one pen drive or a CD, or downloadable some form with the standard, means pre-developed and pre-designed, then it is treated as a means goods. But otherwise, any of the programming, designing, developing, customization, adaptation or upgradation or enhancement of the any softwares are treated as a service. So this confusion earlier was there. Now of course there is no central and state, like only one GST, but earlier there is confusion. The two taxes are differently, their treating is, one is treated as a goods and the other is treating as a service. But now to some extent is been settled down, but these confusions are still persist in many cases. Example, I am an agent in India for a foreign IT provider, principal located outside India. For agency services, I bill the principal in convertible foreign exchange, foreign currency, whether GST liability arises in this case or not. Because this looks like little bit GST subject also, we are anyhow discussing, because it is linked whenever we are talking of services of the import or export. GST matters are definitely covers. So from the GST only we have to make the treatment. Yes, sir. Here, suppose for your principal and agent relationship, and whenever it is coming, the intermediary, the term intermediary service provider, in such case the treatment is entirely different. Some other examples I'll tell you, then I will explain. The intermediary services, the intermediary services will not be treated as an export of services. So what is those intermediary services? I will explain you. The term intermediary is provided in the section this 2.13 of the IGST Act. An intermediary means a broker, an agent, or any other person by whatever name called. Again, they made wider because we Indians are very smart. If the government tells brokers and agents are treated as an intermediary, then you will make some other name, not a broker but not agent, like some other name you will put. Then you start transaction similar like agent to avoid the taxes or to take the benefit of the certain service export benefits you want to take. So therefore, government is also made cleverly that in whatever name you call, maybe tomorrow you call him some other names, may not be broker but distributor. Then, so therefore they call whatever name you call, the transaction you have to understand whether it is the nature of the broker or agent or not. So who arranges or facilitates the supply of goods or services or both or securities between two or more persons, but not include a person who supplies such goods or services or both in his own account. That means suppose you are acting as a agent for your some, for example, overseas customer, and you are arranging the service to Indian exporter, some services you are providing. You are an agent of the overseas customer. You are an agent of the overseas customer. But so you are intermediary. The service, these goods, for example, goods are sold from the overseas to the Indian customer, but you are getting certain commission out of it. Either you are taking from the Indian supplier, Indian recipient or importer, or from the overseas exporter, you are taking certain commission. So when you are taking such commission, like, then it is treated as an intermediary. Then intermediary, when he is providing some certain services to overseas, then that is not treated as a export of services. Intermediary only providing the services for the either the importer or exporter of the overseas. He is providing the services, but he himself not involved in sale or purchase of the goods or the services. He is only taking the commission or brokerage out of the transaction, but the service recipient or this goods recipient or service recipient and service providers or goods providers are different. The intermediary only providing certain services for which he takes the brokerage or the agency commission. Some of them again I will read. This is one of the advanced ruling. Global Reach Education Services Private Limited, and they have the providing the service. What is the fact I will read? The applicant means this is the Global Reach Education Services in applicant. The applicant is engaged in the overseas education advisory services, where it promotes the courses of the foreign universities. In India, a lot of places you must have seen, they are arranging the foreign courses and foreign degrees and foreign even PhDs and etc. On behalf of the foreign universities or colleges, they operate in India to provide the services in India to Indian students. So here this same case, this the applicant, he is providing the services for the overseas clients, overseas universities, foreign universities among the prospective students, and receive the consideration from the foreign universities based on a number of admissions. An applicant is receiving consideration from the foreign universities. What are the services is providing based on generally that is linked to performance, means he means engaging certain students for the foreign universities admissions, then he will get the commission on based on the admissions. Then the issue is whether the service provided to foreign universities by the applicant, whether it is treated as an export of service or not. This is the case. Here it is been treated as a being a intermediary service provider. The place of the applicant is the place of the, that is a place of supply is very important to understand. In this intermediary, the place of the supply is the intermediary place. If the intermediary is in India, therefore the place of supply is in India. Place of supply is in India. Therefore, it is treated as a means intermediary is not a not qualify as an export of services. Therefore, what he has to make, he has to pay the taxes in India, the GST. It is not, two aspects you have to understand. One, it is not treated as an export, so export benefits and all thing will not be entitled. The second, the tax discharge, the GST, the means applicant has to discharge the GST in India because it is taxable services. He is providing from India to overseas, but it is not treated as an export, but it is a service provision. So therefore, he has to pay the tax in India. GST has to be paid. So this is one of the rulings has come. Similarly, to understand more about the place of supply, there are provisions are there in GST for the goods and as well as for the services. Separately, there are provisions for goods. There is a section 7, section 11 covers of the IGST. Section 11 of the IGST covers about the goods. Then section 13, very relevant provision, that is covers for the services. Okay. In goods, for example, goods imported in India, the place of service is location of the importer. If the in case of the export, the location of the service means location of the supply means place of supply is outside India, because it is an export to a person outside India you are sending goods. So therefore, it is location of the outside India only that customer or the consignee is the that place is called as a place of supply. Here is there is general provision that 13.2 in case of services. In 13.2 calls, the location of the recipient of the service is the place of supply, except of course these cases. These are special cases covers under section 13.3 to 13.13. Some of them of course will go, not all the possible, but some of them I will highlight, then we can understand what the cases, how it is happens like. Okay. Here, for example, one of the cases, place of supply related to goods we are talking about. Here, a UK national company place an order to the company of Delhi to service air conditioning plant working in office of the Bangalore. Payment is also received from UK company in foreign currency. whether this is a export or not. Here, what is happening is the place of supply you have to identify. Means the case very clearly, the UK company, they have an office in India, in Bangalore. For their air conditioners services, they have placed an order with the Delhi-based company to provide the services in India. The answer for this is the goods means ACs are situated in Bangalore. Here in this case, this section talks about 13.3a related to the goods. Wherever you are providing the services to any of the machine or goods, then where the machine is located, that is the place of supply. So that is understand. For example, a foreign engineer comes and he is providing the services for a machine in India, for a German company. Suppose they have sold a machine to India, and later some service purpose, the person from German, that engineer, has come to India and provided the services. The machine is located in India, therefore the place of supply is in India. The place of supply in this case is where the machine is located, where the goods are located. Here the ACs, they're making the services. So the ACs are located in Bangalore. So Bangalore becomes the place of supply. So place of supply is Bangalore. Therefore, this transaction is not export of services. Means for this Delhi person who is got the order from the UK and also received the payment from the UK, but is not treated as an export of services. Even though payment received in foreign currency, it is not treated as a export of services, because very clearly it talks about the place of supply. The place of supply happens to be in India, then therefore it is not an export transaction. In the above condition again, the supplier of services of the AC plant working in office situated in India, the supplier this supplier services the AC plant working in office situated in UK, not in India, but UK office of, for example, he is making. The payment is received, for example, in Indian currency, then of course that condition is not satisfied. That means that third or fourth condition, payment related, payment must be received in foreign currency. But if we received from the Bangalore office, the branch office of the overseas customer, but you are receiving the payment in Indian currency, then this is not treated as a export of service, because that fourth condition related to payment is not satisfied. The other case, suppose we take, this is immovable property related services. According to this section, location of the place of supply shall be the location where the immovable property is located or intended to be located. Suppose an immovable property was rented out in Delhi to a foreign national USA. The payment is, though it is received, but already I told this type of cases, but this case again, the the rental property, the property is in India, but is rented to the foreign client. So even though you are receiving the payment in foreign currency, but the location of the this place of supply, in this case is the location of the immovable property. Immovable property is that means that building, for example, is located in Delhi. So Delhi is the place of supply. Therefore, it does not satisfy the third condition of the service exports. So therefore, it is not treated as an export of services, though it is received in foreign currency. Like that, other cases also there. Of course, so time is short, so I'm little bit skipping out. Place of supply for intermediate also very clearly mentioned. All the cases also they clearly mentioned. But intermediate services always there is a certain confusion, and also certain related to litigations also there, because it has a different understandings. And distinct persons also, earlier there are a lot of confusions are there. Who is a distinct person? On that, many clarifications are issued by the this GST board, which is CVIC, and also there are certain advanced rulings are there. Then of course now it is almost like little bit settled. The settled condition is now, for example, you are in India, have a business, and you have engaged some your license office in say in Dubai, and you are making the certain services to Dubai office. From the Dubai office, you are getting certain payment in even though foreign currency, but these are not treated as a transaction, means export transaction, if that Dubai office is not registered in Dubai or foreign country. But if they are operating just like in license office, then these are treated as a distinct person. So the services provided from India to Dubai then is not treated as the export of services. Very clear. But in case, for example, TCS, then Infosys, like many of the Indian software companies, they have raised the issue because they have many offices abroad, and they are providing services from India, and vice versa also they are getting and going off. Then these are treated as a distinct person or not, the issue as raised. Then it was clarified very clearly. It was now very settled case. If the TCS, for example, they have in Indian operations, but whenever there are overseas operations, in overseas, suppose they are registered in overseas country as a separate entity, then these are not distinct persons. Then these are not treated as a distinct persons. So therefore, from India, what are the services providing to the other office in, for example, in UK, so that transaction is treated as a export of services. Okay. So therefore, export benefit you can enjoy. But if not registered in overseas, that branch or office is not registered in overseas, then of course it is treated as a distinct person. In such case, distinct person, this tax it is will not be treated as a export of services. Therefore, whatever the treatment has to be done as a domestic supplies, that treatment has to be done. There one circular is there. In certain cases of the that distinct persons cases, that GST is made as a nil. The GST rate of GST is made as nil, even though it is very clear that distinct person, there is no, it is not treated as an export of services, but it is the same office like we are treating. So therefore, the government has issued a notice, this notification. Through that notification, it is now GST is not applicable. It is not treated in export, and also Indian treatment, that Indian domestic supply, like if you treat, then the tax is exempt, means made at nil. So therefore, this treatment has to be understood. Okay. Like many other cases, the Nepal cases, for example, whether the supply of services to Nepal and Bhutan in Indian rupees are liable to GST. Here in this case, as per the RBI regulations, we may allow to receive the payments from Nepal, Bhutan, Indian currency. Even though we receive the in Indian currency, for the treatment of export, it should be treated as an export only, not otherwise, because that fourth condition about the payment, there is certain exception for the Nepal and Bhutan, where as per the government regulation, mean RBI regulations, it can be treated taken as a in Indian currency. But when you are making any services, whether if you received in Indian means Indian rupees, no, GST need not be paid. The services where the place of supply is Nepal and Bhutan, against payment in Indian rupees, are exempted from the GST. And also further, for the remittance of the services, as I told, there is a relaxation. So this covers under the export of services. So export benefits you can get it. Then export of services treatment in India, yeah, GST, because these are treated as the interstate transaction. Whenever you are making export outside India, these are treated as an export, means interstate transaction. So IGST, if any, is applicable. Okay, IGST treated as a zero rated supply also, because in outside India we are sending this export of services treated as zero rated, and ITC is also allowed for the providing the services. What are the your incurred certain expenses, for example, on which suppose services you have received or some goods you have received in our organization you have purchased, on that ITC you can take it. So export of services is defined. The export of services again you can do in two ways. One is export under the LUT, means without payment of the tax, then you can claim the ITC refund. The other one is you pay the IGST, then claim the IGST refund. Both the options are available. As I discussed some time back, for the purpose of the goods and for the services also, the same provisions are available. So either of the options you can take it, which are suitable to you. Whether service exporters compulsory to register with the GST or not, that question arises. Yes, because it is treated as a service, means provider of the service, provider of export of the services. What of the services or goods you are providing, exporting, then is treated as an interstate transaction. When the interstate transaction is there, there is a compulsory registration provision is there under section 24 of the CGST Act. So you have to compulsorily take the registration, compulsory registration, section 24, as I told you, you have to take the registration. That is mandatory. But lot later they provided some relaxation. If the service provider has the turnover less than say 20 lakhs, there is threshold limit for the GST, then of course the relaxation not required, otherwise it has to be taken. LUT, as some time back I discussed, for any of the exports, if you want to export either goods or services without payment of the GST, in such case you have to execute a LUT. LUT is valid for 1 year, effective from the 1st of April to 31st of the March of the subsequent year. And this eligibility any exporter can do, means zero rated suppliers, they can apply for the LUT, except in cases where a person is prosecuted for any of the tax evasion which amounts to be more than 2.5 lakhs, 2.5 crores, means 250 lakhs. Okay, zero rated we understood outside India, export outside India or supply to SEZs also treated as an export, that is a zero rated undertaking has to be made. This is how the LUT related. Then refunds also you can get, as I told you, either ITC refund or IGST refund. In the first case, for example, you are making the LUT, execution of the LUT without payment of the tax. In such case, you can export the goods under the LUT, and what are the unutilized this ITC is available with you, you can claim the refund. For the claiming the refund, you have to file a form, that RFT01. So in that form, you have to file and get the refunds of the export of the ITC refund. And the refund can be claimed within 2 years. The refund must be claimed within 2 years. And generally within 60 days, your refund claims have been settled. If not settled, the government will pay 6% interest on non-payment of the, what are the non-payment of the refund happened, on that 6% interest the government will pay. But of course all the conditions you have to satisfy, then only that triggers for the refund, not the application you have made, and it is not a criteria. Once you make the application, then it has to be ensured that that application is accepted, acknowledged and accepted, then only it happens. Otherwise any deficiencies are there, then it will not be treated, that application will not be treated. Once your deficiencies are fulfilled, that date will be treated as a fresh application like. Okay, something. Then commission agent and all things we have discussed. Intermediaries, commission agents, some cases we are already discussed. So I'm shifting. Some commission agents again for clarity, let us understand. One scenario is the commission agent as well as the principal both are in India. Both are in India. Commission agent is in India. The principal, he is also in India. You are providing the services as a commission agent to Indian principal. Okay, so both are in India. In such case, the commission paid and everything. In such case, it is not treated as a export of services. Here, the supplier and recipients are in India. Therefore, the place of supply would be governed by the default provision of Section 12.2 of the IGST Act, and it will be the location of the principal. The principal where it is located as per the section, that is the place of supply. Because in supply service cases, the place of supply is very important. Different provisions are there. Section 12, 12 and 13. The section 12 and 13 of the IGST Act governed by the provisions of the service place of service place of supply for the services. Okay, here in this case, both are in India. As per the provision of the 12.2, the principal where he is located, that is the place of supply. So therefore, the place of supply is in India. So it is not any, CA is not applicable. But of course, the transaction between them, it is subject to GST. And it is treated, if the same state, both are there in the same state, then it is a CGST plus IGST will be applicable. Otherwise, if they are in different states, then IGST will be applicable. So it is purely like Indian transaction. Then the other one is one of them is outside India. Either the commission agent or the principal is outside India. For example, here we assume the principal of this transaction is outside India, the commission agent in India. Of course, the payment received. In such case, this is the treatment of the intermediary services, they call it. When the intermediary services, the location of the supply is the supplier's location. Supplier is in India, means the location of the supplier, that is in India and liable to GST. He the service is providing, he is the provider of the services, so he is the supplier. So his place is treated as a place of supply. It is not an export. Therefore, because he is the intermediary services provider, so therefore GST is liable. Similarly, other cases also, suppose the commission agent is outside India and principal in India, then the place of supply is outside India, because the supply provided is outside India. The location of the supplier is outside India. It is non-taxable territory. If it is non-taxable territory, then GST is not applicable. Since it is not treated as an import of services, again is not treated as import of services. Therefore, no IGST is payable for the principal, because the agent, the commission agent, and the services provided by the commission agent to Indian principal, it will not be treated as a import of services. So no IGST shall be payable by principal under reverse charge mechanism. Otherwise, import of services attracts the GST, means IGST, on reverse charge mechanism. But in this case, because there are the relationship is agent and the principal, intermediary services, so therefore it is not treated as the import of service, and IGST that on reverse charge mechanism need not be paid. So okay, some other things also there. Let me move forward. one important case also we have to understand. This is an advanced ruling in Odisha. It happened. The Tokyo Electric Power Company, they are providing the services to Indian entity Odisha Power Transmission Corporation. Okay. But they are providing the services here. Is the Tokyo Electric Power Company, Japan-based company, in association with the this Tokyo Electric Power Company holding in, that is in India, a Japan-based company, but in India it is written. In India they have the operations, has entered into an agreement dated so and so with the Odisha Power Transmission Corporation, whereby the consultant provide the services to the OPTCL. This is the case. This is the background. The applicant will provide the and transfer the technical knowledge in relation to the outdoor geographic information system (GIS) to the this Odisha Power Transmission Corporation. Okay. Here it is held that the supply of the consulting services through substation engineers and experts of the applicant to this Odisha Power Transmission Corporation belongs to the applicant should be treated as a supply located in India and may liable to pay the GST. Here the treatment is what they did is the Tokyo Electric Power Company have certain engineers in India, and through that Indian setup, that is the Indian company, India, they have made an office. From there, they are providing the services to the this Odisha Power Transmission. In this case, it is held that it is in India, it is when transactions is made. So therefore, it has to be paid the GST. Not it is treated as an import and other things, but simply it is treated as a GST located in India and made liable to pay GST. Okay. So many other such cases are there. Okay, some import cases I'll discuss about the import of services. Import of services. Import of services. The recipient of the services who is in India liable to pay the tax, that is the IGST under RCM mechanism. Under RCM mechanism. Suppose the import of services is received for a consideration, whether or not in the course of or furtherance of business, whether you are in the business or otherwise also, if you are making any of the import and for that consideration is made, then it is treated as an import of service. That is what the provision. Okay, treated as a supply and it is a taxable. This event is taxation, and this is applicable on the import of services is applicable on the RCM basis. We have to make the payment. This is the notification accordingly. Okay. Here the import of service with or without consideration. Here the when consideration is there, then it is treated as an export of import of services. If consideration is not there, of course no, it's not there. Even though in the course or furtherance of business, but if it is a related transaction, the transaction between the related persons or from any of the other establishment outside India is treated as a supply. So the RCM basis, the GST is payable, that is IGST has to be paid if it is import of services. Then trade agreements, let us come to the trade agreements. Trade agreements, India and very many of the foreign countries, we have entered into some of the trade agreements, and trade agreements are the different types of trade agreements are there. These are the different types of trade agreements. For more details, you can refer to the DGFT, the appendix 2A of the handbook of procedures. these are the three broadly, means four are there different means yeah, treatments are there, different agreements are there. One of the very popularly we are talking about is the free trade agreement, that is the FTA, free trade agreement. In the free trade agreement, then preferential trade agreement, what is the difference also I'll tell you. The free trade agreements mean, for example, we and the Asian countries like Sri Lanka, Bangladesh and many other countries are the Nepal and other countries, we are entered into the agreement wherein if we are importing from these countries, India will provide certain concessional rate of duties. Similarly, Indian products are being exported to these countries. These Asian countries, they will provide some concessional duty for Indian products. So this is the agreement happens. Okay, means both ways. Some of our we will benefit some for our products of export, and also they will benefit for their export to India. Means for India it is import. Okay, so whenever the imports are happening in respective countries, they are providing to the partners certain concession in duty. Okay, certain time exemption or certain time concessions. It's not like always exemption or very means nil rate of the customs duty, but there may be some reduction in customs duty. That is what they make it free trade agreements. Okay, and in the free trade agreements, they will be for all the products it is applicable except the negative list. The negative list products which they provide means write down this agreement, they write down the negative list. So negative list, except the negative list, all other products the concessions are applicable. Except the negative list products, all other things the concessions will be applicable. Okay, that is called free trade agreement. Some of the free trade agreements and other thing I will show you in the portal, so it will be very interesting to understand. So whenever you are making an export or import, you have to see into the whether free trade agreements are there or not, so that concessions are available or not, because it's a business benefit for the individuals. Suppose you are exporting to Sri Lanka, for example, and Sri Lankan government is provided under this agreement certain concessions under this duty concession for the year, then you can properly negotiate considering these factors, so that the importer will be more competitively can import, and for him it is more competitive rather than purchasing from the China and other countries. So therefore we have to understand this and educate also certain times. Look, this is a benefit you are getting. So when you are importing from India, and these are the advantages, like that you can tell to your overseas customers. So therefore FTAs are very important aspects to understand. Then there is another type of agreements, those are called preferential trade agreements. The preferential trade agreements are, the difference between the FTA and the PTA is, in the FTA all the products are subject to the concessions except the negative list, whereas in preferential trade agreements only there is a positive list. They are list out, these are the products, only for those products the concessions will be available, not for all. But in FTA, free trade agreement, all the products are subject to concessional duty except negative list products. On the other hand, preferential trade agreements, the concessions are available only to the positive list. What is the list is given, only those items are subject to the concessional benefits. Then there is some other type of agreements, like a comprehensive economic partnership agreements. Here it is not just the products and all thing, but they are means to some foreign countries, the partner will invest in India. For example, Japan has invested in India for for example NMDC. They have an agreement with NMDC to provide infrastructure for the rail. This Coromandel rail route is there from Visakhapatnam to the Chhattisgarh. From Chhattisgarh they are extracting the iron ore and they are exporting to China, Japan. This is for the long years they started this agreement. Under the agreement, Japan has invested in infrastructure for the development of the rail route from the mines to Visakhapatnam port, so that they can export that goods. So that all investments and all the Japanese are made. So under such agreements, the partner will make the investment for the development of certain infrastructures in India. Then exports will start. Then whenever the goods are being exported, again there is a treatment. There's a concession duty of our Indian exports to Japan. So these type of agreements are called comprehensive economic partnership agreements. And there are customs union like agreements also there, especially in European Union. All the European unions, there is a like one union, that customs union we call it, so that the goods and other thing can move very freely. There is no much of the restrictions, so they can make the movement of the goods and services across those countries, the European Union countries, free. So that type of transactions called common union. And many other transactions, case to case, it can be done like common market or economic union, like that. So these are the some of the free trade agreements are there. And free trade agreement, some of the list as per the handbook of procedures, these are the some of the list we have. The India has a certain agreements with various countries. We have a with Sri Lanka, we have a FTA, India and Sri Lanka free trade agreement. Under the free trade agreement, all products have their concessions except the negative list. Then we have an agreement on South Asian free trade agreement, that is SAFTA. Nepal and Bangladesh and many other countries are there in this SAFTA. Then revised agreement cooperation between the government of India and Nepal. India and Nepal we have an agreement. Then India Bhutan we have an agreement, and India Thailand we have an agreement. And recently, of course, you must have heard in last 3-4 months, we have done many agreements. One of the agreements we have done with Australia. Australian Prime Minister also come to India, and we have an agreement for the India and Australia. And recently, British Prime Minister also arrived to India to sign an agreement. Means recently they are going for the agreement, that is not finalized, but under discussions. So they want to, we and UK want to have an agreement for the trade agreement. Okay. Similarly, many other countries also coming forward for the trade agreements. And some 4 months back also, from UAE Prince has come to India and signed an agreement between India and UAE. So the agreements promotes the trade. The trade agreements promotes the trade where both the partners will be benefited. So some of the goods are essentially required in that country, for example UAE, and from UAE also we want to give some concessions if anything is imported. So both the countries have agreement to give certain concessions. Similarly, investments. Okay, such agreements are happening. And recent agreements I told you, like UAE we have an agreement, Australia we have signed an agreement recently, and with UK we are under negotiation. And for the US, of course, we had long battle of negotiation, but we are not coming to settlement because the demands are very high. So therefore, we are not able to settle. But US also we are in discussions for quite long years. Now I will show you practically on the site where these are all available, the details. India Trade Portal, I told you, India Trade Portal. In the India Trade Portal, if you go, you try to go and see yourself, many beautiful things are available here. Lot of related to trade, import and export. The data are available here. That informations are available. Most of them, there's no fee or no registration restrictions are there. Everything is like free here. You see the trade agreements which are in force. So each of the force, you see what are the PTAs, what are the CEP, means the economic cooperations. comprehensive economic cooperation. I told you India and this Republic of Mauritius and many other countries are there. This is for the United UAE, and these are the recently we have done. Like many such things are there. Like this, all you can see this PTA with the India and Chile. Like many of the recent agreements we have. So all these things are available here. You can go through and have a look. And if you open these details, for example, India and Africa trade agreement, like this India and Africa trade agreements, what are the trade agreements we have individually with countries, it is available. India and Mauritius, for example, very popular agreement, this one. So when you click complete this agreement related things are comes. So you see this in agreement we have India and Mauritius. So whenever you are making any export or import, you can go through these details so that both the partners will be means whenever you will export or import, you can guide them. These are the benefits are available so that you have a competitive edge, because once the concessions are there on the customs duties, that is beneficial for the both the parties. And our import and export products also, when you want to know about what are the means export market, import market, you can click here. This you practice is many times I used to tell you practice these things, open this one and go through and practice yourself. There is no registration fee and nothing is there. It is a free. It is FIVO has developed Federation of this one. FIVO is developed Federation of Indian Export Organization. They have developed this site and very excellent site. Most of the informations are available in one place. So export of say 25 export markets, like individual country wise export. For example, USA, what are the major products goes into the USA related, all the transaction related are import and export policies like that. All these details are available. Suppose in UAE, if you see the tariff related and other things, whenever tariff you require in US, what is the tariff for any particular products, you can type here and you can search. Similarly, here, what are the import policy of India from USA, for example? So like that, you can see and you can find out import particular product. You have to select, of course, on the particular product. They will give you the details about the whether free or any restriction or other things they can tell you. So this is how you can take the advantage of the country wise specifically, and country wise any trade statistics also if you want, that is also available. Trade statistics, for example, these are the trade statistics. What are the product and why, when for the last 3-4 years they are giving the complete details. Okay. So like this, you can get the advantage of this portal, very beautiful portal. Okay, and various other resources also there, like export promotion bodies, means foreign means export promotion councils. You see, like this, it is available here. You need not search anywhere. Yeah, all the details are. That is why it is very beautiful portal. This in export promotion councils. Then other public sector undertakings and other organizations. Then international trade bodies also available here. Whereas the various international trade bodies by WTO or World Customs Organization, all the details, brief details, of course, which are essentially to understand whenever you are going into the import and export field. And similarly, the custom duty calculator is there. Sometime back I told from the ICE gate. From the ICE gate you can calculate. Here from here also you can calculate. And also all the acts are there. The GST or Customs Act and other related acts also available here. You see the Customs Act, Customs Tariff, Foreign Exchange Manual. So all these things like available in one source. So you need not ask anybody. Everything is available in this one source. Most of the details about import and exports, make in India, what are the facilities and all things now government is announced, like this also available. Of course, it takes in the next another portal. Uh, so that is the opening. So like that, you can go through this. Lot of benefits are there. Then you will really become an expert when you search on this and study. And foreign buyer and this also they made certain tenders or any of the information. So anybody makes, for example, enquiries, those enquiries related also they started posting here. So that the advantage of it. So avail of this portal, the facilities. So Make in India, what are the latest provisions they're making, especially in Make in India, latest some provisions for the investments in India in certain categories like PLI means some means some, for example, electronic goods. Mostly you are importing. Instead of importing, you are now getting certain benefit if you manufacture in India. So like this, what are those products and all thing also you can find out. So this is how the related details. Okay. So can we take a small, let's say 10 minutes or 15 minutes break? A 15 minutes break we can take and we'll come back. Yes, sir. Let us take a 15 minutes break and we'll come back. Then I will show you about the export logistics related aspects also we'll discuss. Okay. About the service export and imports I covered. Now let us move to the export logistics. Important some of the aspects we'll discuss in export logistics. Export logistics, when we are talking about, immediately comes our mind, or a very important aspect is about the Incoterms. So Incoterms should be very clear. Incoterms, sometime back briefly I mentioned, Incoterms are developed by the International Chamber of Commerce, and these are been means in practice over the 120 countries. 120 countries adopted, signed the these means of convention, so that this is effective for all the 120 countries across the world, and the meaning will be the same across all the signatory countries. Okay. So here there are 11 terms are there as per the latest Incoterm, and whenever you are writing the any of the agreements, you have to write very clearly the Incoterm. What is the version? This version is 2020 latest version. So you have to write very clearly Incoterms 2020. Then only this new version is applicable. If you are not writing any Incoterms, like many people talks about FOB, this JNPT for example, they writes, then after they will be silent. That is not a correct practice. So those things, like what are the requirements, I will explain to you some of the important aspects. But many things are there, but everything is not possible in given time. But some of the importance I will tell you. The Incoterms, it covers for the obligations, means what are the both the parties, the buyer and seller. This is in between the buyer and seller. What are the buyer's obligation, what are the seller's obligations are mentioned in these three letter trade terms. That is Incoterms. One is the obligation, the other was cost. Whenever the transactions are there for the movement or otherwise documentation or insurance or other costs are there, freight payments and etc. So the cost also, who has to bear that cost about the freight, either it is a domestic or it is ocean or other rail or other means of the cost of the transportation. Who has to bear the cost? Who has to bear the insurance? And who has to bear other incidental expenses like loading, unloading, customs clearances, and our port clearances, and all these things, and that customs duties, and who has to bear that cost? That is also very clearly mentioned. And also, if anything happens, any mishap happens, many damages happens, then who has to bear the risk? So these also been mentioned very clearly in the Incoterms. So that is why these are the trade terms, very essential. These also called as the delivery terms, means where it has to be delivered, the location it is also mentioned. So therefore it is important for any of the trade agreements you are, means you are signing any contract for import or export. These Incoterms understanding is very essential. Okay. Just a minute. These all import and export you have to make. In one case, we are making this case study one. Here, the buyer and seller enter into the agreement, and you had to make the, sorry, just a minute. Here, let us understand this first case. There is an agreement entered into the Indian seller is buyer. The terms of the Incl term is FOB JNPT port. The seller arranged the goods according to as per the contract. However, before the cargo loaded into the vessel, an accident happened. An accident happened. For the goods are damaged, then the problem of who has to bear the cost and damage of the damage or loss. Who has to bear the loss? Who will arrange the insurance and claim the damages? So this is the question. Here in this case, because it's an FOB consignment, and as per the FOB consignment, the obligation, if you see, the seller's obligation means exporter, that Indian seller means Indian exporters, the responsibility is to put the goods on the board of the vessel. They put the goods on the board of the vessel. Until that, it is the responsibility of the supplier or the seller. And what are the costs also there, up to that the seller has to bear. Any risk also happens, it is seller's risk. Okay. In FOB, the insurance, after it is loaded on the board, from that point till the destination point is borne by the buyer, but it is not happened after boarding. It happened, the damage happened before boarding. Therefore, it is the responsibility of the Indian seller only. So these type of obligations also you have to understand. Therefore, the responsibility, cost and risk up to the loading of the goods on the board of the vessel is with the seller. Seller has to bear the cost. Seller, if he is making insurance, he can claim the insurance. Otherwise, it is seller's responsibility. Buyer is no way connected. But buyer will be connected only when the goods are boarded on the vessel. Then after, all the transactional costs and nothing on the buyer's, that is obligation of the buyer, and the buyer has to bear the cost. The risk also the buyer has to bear. Okay, so that is what is very clear in this case. The second case we'll see. An agreement entered into the Indian seller and the overseas buyer for delivery of the goods on the CIF value. CIF means cost insurance freight till the destination port. The destination port also they mentioned. This is the destination port. C till Tacoma is the destination port. Till that destination port, the insurance is taken by the seller, and ocean freight till that time, till that it reaches the destination port, that is also borne by the seller as per the CIF contract, because it is cost, insurance and freight. CIF means cost, insurance, freight. Okay, but something accident happened. For example, this year started new between this one. Here the buyer argues that since the seller arranged the means something mishap happened, damage happened in the accidentally after the sailing. So then the buyer is talking about, since the seller is arranged the insurance and it is his own cost he has arranged, it is also the insurance is also in the name of the supplier means seller. So therefore the buyer argues that the seller has to bear the cost, or insurance has to claim, the seller has to claim. So what is the position actually? CF means, of course, very clearly it is the insurance and freight has to be borne, the cost has to be borne and made arrangements by the seller. Okay, loading on the carriage charges, insurance, all these things has to be borne by the seller only. But under CIF, very clear these terms, the CF risk in the goods passes from the seller to the buyer at the time the goods are loaded and stored on the board of the vessel. Once he has put the goods on the board of the vessel, though the insurance is covered by the supplier, means a seller, okay, but the insurance now is like transferred to the risk is now transferred. Once he put the goods on the vessel, then the risk is transferred to the buyer, not to the seller. Up to the buyer is transferred. So therefore, whenever we're talking of the Incl terms, you have to very understand who is the obligations and what are the costs and what are the risks also. When the risk will be transferred, that is very important to understand. The risk in this case is transferred from the seller to the buyer once the seller has made arrangements to put the goods on the board of the vessel. So after that, the risk is transferred to the seller, buyer. The risk is transferred after that to the buyer. So who has to claim now the insurance? Though the seller is arranged the insurance, but it is the responsibility of the buyer to claim the insurance. Not it is the responsibility of the seller, but it is the buyer's responsibility. Then an insurance is written in the name of the seller. No doubt it is written in the name of the seller. But when it is handed over that insurance copy, insurance policy, then the buyer has to claim based on that. He has a recipient, he has the risk bearer now. So he has to claim the insurance from the insurance company, but not the seller. Okay. So these things has to be understood. Otherwise, many times this type of risk happens in the transaction. Here is the case study 3. An overseas buyer in New York enters into DDP, means delivery duty paid deal. This is one of the Incl term. This is one of the Incl term, DDP, with the seller from the India. The DDP term, the first state that the address and other things are given, exactly that location. DDP means the duty paid, delivery duty paid. DDP means delivery duty paid, means it has to be delivered at the concerned place after making the customs duty at the import means country. That customs duty also has to be borne by the supplier only, means exporter, and delivered to the doorstep of the buyer. That is the DDP. But suppose here also some damage happen in the transaction, then who has to claim the insurance? The seller bears all the costs, risks involved in bringing the goods to the place of destination. In this case, the risk is transferring, means this risk is borne by the supplier till the delivery point under the DDP. So till the delivery point, that's risk is borne by the seller. So it is the seller's responsibility to claim the insurance or bear the risk. Okay. So therefore, here from this case studies, what we have understood is, first we have to understand up to what stage the risk is covered and who has to bear that risk, either the buyer or the seller. Very clearly has to be understood. That is where it is Incl terms they mentioned also. Under each of the term, what is the means, these are three aspects we have to understand. One is the obligation. Obligation means who has to arrange, and then the next is the cost, who has to bear the expenses. Then the third one is risk, when the risk is transferred, at what point the risk is transferred. So that is very important. Even though CF, I told you, CF, it is written very clearly, the risk will be transferred the moment you put the goods on the board of the vessel. The risk will be transferred to the to the customer, the importer. Okay. So therefore, here in DDA, the risk is with the supplier till the delivery of the delivery point. The risk is with the supplier only. So like that, you have to understand the risk point, where up to what point the risk is covered. So accordingly, you have to means to make the transactions. Otherwise, certain times litigations happens without knowing. Most of the times we are doing the transaction, we are entering the agreements also, but certain things, some incident happened, then we are in a trouble. What are the covers in the Incoterm? Like Incoterms covers what is the responsibilities and all these things about the buyer and seller, about the furnishing of the goods, packing, marking, leveling, warehousing, loading, unloading, inland freight, inland transportation, and also terminal handling charges. Terminal handling charges in two places. That is your domestic terminal handling charges, means in the exporter's place. Then terminal handling charges at the destination port. So both has to be considered, who has to bear the cost. Okay. And also the freight forward selection, their fee. Export clearances, means customs clearances, and customs clearance related all the expenses are port clearances. Then import duties, and freight or ocean freight or sea freight or other means of freight, and export duties or taxes, or delivery and specific place, security clearances. All these things are covered under the Incoterms. So therefore we have to clearly see that what is the term you are using, under which what are all the obligations, what are all the costs, what are all the risks. Accordingly we can enter in the agreement. Okay. So totally these are the total 11 Incoterms. These are the 11 Incoterms. Whichever is suitable, you have to see. Of course, there are certain Incoterms are, these are based on this classification. Sometime back I discussed this Incoterms. There are multimodal Incoterms, and any means marine only Incoterms. Multimodal means any type of transportation, either it is by road or rail or by air or by sea. So these are multimodal transportations. These is like XWorks, FCA, CPT, CIP, DUP, DPU, DAP, then DDP. These are the 7 Incoterms covers under the multimodal, and others like these 4, FAS, FOB, CFR, and CIF. These are under the marine only, and other seaways only covers. The responsibilities and other things I mentioned here, like who has to bear, either buyer or the seller, according to the each of the Incoterm. These are the 11 Incoterms accordingly we have mentioned. So you can go through it whenever they required. Is a chart, like whenever you're entering, you can enter into this agreement with understanding what are the obligations and what are the costs and what are the risks. Whenever you're choosing the any of the Incoterm, you're writing down, choose the right Incoterm, that rule. That with the rule means that whenever you're writing the Incoterm, you have to write very clearly, like this. For example, I have shown FOB. After the Incoterm, the place must be written where it has to be delivered, because these are delivery terms. So the the place must be mentioned, either port or any other place, warehouse or other things, anything there. That place must be mentioned very clearly after the Incoterm. Okay, followed by the present. What is the Incoterm? That means this rule what you are talking of, the version. The Incoterm every 10 years they are changing. So earlier one is Incoterm 2010. Now is it 2000 means 2020. Again on 2030 there is another Incoterm will come. The version you have to mention, then only these applicable terms, and those are binding. If you're not mentioned Incoterms, that words very clearly you have to mention Incoterm, which version 2020, like then this 2020 what are the versions are available, the terms and conditions are available, that obligations, risk and costs are mentioned, that is applicable. If you are silent, then no terms is applicable. Though you are written FOB or CF, whatever may be, that has no meaning. If any litigation happens, then it is a no meaning. But one general clause like you can take, in case of the options, in case of the signatory countries, only those signatory countries, then the latest version is applicable. That is the default condition. Okay, if it is non-signatory countries, if you suppose you are exporting to any of the non-signatory countries, then the risk again on you, because these are not applicable. And the Incoterms are also voluntary terms. It is not a mandatory, but voluntarily, if you want, you can do, otherwise no. But it is essential, because all the customs clearance, when it is making, customs people ask very clearly which Incoterm. Similarly, bankers also ask without Incoterms they can't entertain any documents. And also shipping lines, they also wanted, because where it has to be delivered, so that Incoterms talks about delivery terms. So therefore, for the customs, for the shipping lines, and for the banking purpose, that Incoterms are mandatory. Otherwise, Incoterms, they themselves told it is not a mandatory, but applicable practically it is a mandatory. Some of the I will show you how the transactions happen. Some video, let us see. You tell me that video is just a minute. Okay, good, interesting. Hello, hello.
Yes, sir. Good, sir.
So interesting, interesting.
Super.
Okay, then type of ports. Okay, understood. Like different type of ports are there. I'm not much discussing a theoretical part. So these are the then selection of the mode of means which mode of the means transportation you have to select based on the various criterias. One is the nature of cargo or the product, then location, then value and volume. Based on this, generally we take the decisions which type of means mode of transport, whether by road, by sea, or by rail, or by air, that we have select based on certain criteria. And these are the very fundamental one. Then of course other factors like accessibility and traceability, reliability and authenticity, flexibility or suitability of the requirement, safety or security, transit time, cost. Based on these certain factors, we generally decide which type of mode of transportation we have to adopt. There are various options are there. Railways means through rail you can means air we can send, or seaways we can send, railways we can send, road or pipeline or conveyors like that. Okay, based on the various factors as I explained to you. Okay, then there is a types of containers. The type of containers, there are various types of containers are there. We have to understand what type of is suitable to us, whether it is standard containers like 20 feet or 40 feet containers with standard dimensions, or we can take the high cube containers generally taken when there is a suppose the weight is less but volume is more. Suppose cotton you are want to export cotton, or the insulins items you have to means insulins items you have to send, which is a very lightweight but volume wise it is very high. So in such cases, we prefer the high cube container where the height will be higher than normal standard container, so that more material can be stuffed, because weight is less anyhow, but volume it can occupy with more space is available in the high cube container. Then open top container generally for the odd dimensional machinery like consignment you want to make the movement, then we use the open top containers. Then open side storage containers. This is from this means generally the back opening is there, that is a normal standard back opening, but there are for specific purposes maybe side opening also preferred, because it is loading or unloading is advantage if you make from the side open. Okay, so side open containers also available. Then flat rack containers, double door containers also available, means both sides back and front, I mean, so that opening. Then refrigerator container, for example, from some food items you want to supply, and for that these refrigerator containers are there. Then for insulated or the thermal containers, heated containers, certain times we have to maintain certain heat, so for that the heated containers. Then half height containers, heavy items, for example steel, that steel bars and steel yeah, structures, if you want to send, that will not occupy much of the space, but it is a heavy weight, so that at the bottom it covers, but under container will be empty. So therefore when we use that such type of cargo, we can use the half height containers, because volume is not required, only that weight is heavy, so that volume will unnecessarily empty containers going at a lot of the volume, means the space is empty, there is no use. So therefore what they do, they make the half size, so the more of the containers can move into the vessel. Then intermediate bulk shift containers, then tank containers like oil tanks and all thing also through that is also we can send any of the liquid cargo, that can be sent through tank containers. Then car carriers, for example cars to transport export, then there is a different type of car carriers are there. In one carrier maybe 8 cars or 10 cars can go in one carrier, like, so those are called car carriers. Then air mode containers. Air mode containers means for the airport, means for the normal containers it can't be possible to send through air, but for the air there are certain type of containers are there that can be used for the air consignments. Then any special containers can be used. And the type of container, one video I will show you, let us see. Okay. So next we will go. Just a minute. These things we have discussed. And yes, in the container selection, some other case studies I'll tell you. Generally, we make certain mistakes in the selection of the container. Case studies I will tell you. So the first case study, suppose you make a machines and steel components were stuffed into a container and sent. Pre-shipment inspection, before sending the consignment to the overseas container stuffing and everything, the pre-shipment inspection was also done, and proper loading and products and other things also identified. Specifications are okay, and physical conditions also and packing conditions also inspected, and is everything is okay. Accordingly, the consignment was sent overseas. When it reached the destination, and they found the supplier, this importer, they has found the steel consignments are rusted, not fit for use, and therefore he has made a complaint to the exporter. Then exporter tells, look, as per your requirement, as per your terms of the conditions of the year contract, I have arranged the pre-shipment inspection. The report also provided to you, that original report. So there it is very clearly written that inspection has been done related to the product and its specifications, related to the loading, packing, and physical conditions. So all the physical conditions and other things are okay as per the means exactly as per your requirement, as per the contract. So the exporter tells he has done correct shipment, but the customer who has received the consignment, he has made a complaint. No, I can't receive and I can't accept this one, because the products are rusted and is not useful for uses. Okay. So now who is wrong now? Whether the exporter wrong or the buyer is wrong? Buyer also made that he can make an inspection, some third party inspection agency, so that the report you can see that the product is rusted. So the buyer also, the importer, he has arranged a third party inspection, and both are selling. In the exporter side, the exporter arranged the third party pre-shipment inspection before the export, and the importer also arranged the third party inspection year certificate, and both are contrary. Then how to go about? What went wrong? Actually, nobody is wrong, but the thing is that the selection of the container is wrong. There are different types of container. Suppose you not properly taken the container selection, then this type of mistakes can happen and disasters can happen. What exactly happened is, here the container what they selected is the G1 type of container. The G1 type of container have a passive vent at the top. The ventilation is vent is there at the top of the passive vent, we call that, is there at the top. So those are specifically adapted for the food items, not for this type of steel and other thing. Because of the vent, the sea air, when it is going, the salty air enter into the container and damage the steel items. So therefore the steels get rusted. So you see, it looks like you are selected everything, you have done every care of exporting, but small mistake in proper selection of the container, there it all went wrong, and you have to have a heavy penalties or heavy liabilities. So when you're taking the container selection, be sure whether it is with passive vent or not. G1 type of things are with passive vent. Those are especially for certain food items, not for this type of steel. Okay. So next case, another case we are talking about. Here in this case, the Indian exporter sent 2 containers of the load, 2 containers of the non-basmati rice he has sent to Iran. And the consignment of one of the container was rejected. 2 containers they sent, 1 container is rejected, the other one is okay, accepted. But he has exported from the same lot, same material, on the same lot, he has made into 2 containers, and 2 containers went, 2 containers of the same dimensions and everything, it went there. But 1 container of the consignment is accepted, the other one is rejected, because in the second container which is rejected, there some pests are there, insects are there, because that rice is contaminated with insects and pests. Then in this case also the dispute happened. In this case what happened is, the exporter is telling both the consignments were loaded from the same lot, and also pre-shipment inspection also was arranged, and the certificate also arranged from the third party. So therefore the exporter tells he is not responsible for, he has made everything in good condition. But the importer contains that buyer, he tells he also arranged some inspection, and from there he has found that the material is completely 1 container, the other container is accepted, but 1 container which is rejected was caught with pests and insects. Therefore he is not going to release the payment or something claim he has made. He has rejected that consignment. He has sent the photographs also, as he arranged the third party inspection, those photographs, that reports also he has sent. Then what will happen on investigation? If you found here they have used the G0 type of container. G0 type of containers doesn't have any ventilators at the top. One is the G0, the other one is G1. G0 doesn't have any ventilators, but the G1 has the ventilator. So G0 containers which we are get it affected with the fungus and pests, because the dormant insects inside the container were germinated because of the hot moisture. There the food items, it's supposed to be went with the G1 type of container, but it has used 1 container G1 but other container G0. But ignorance, he don't know about what is G1, what is G0, but simply he called the containers, and incidentally 1 container has come as a G0, the other container has come as a G1. So therefore the G1 container is selected, means okay, accepted, but the G0 container, the material is rejected, because the pests are germinated within this, because of the hot moist within the container, the germs are developed. So therefore the pests and fungus and all things formed, so that was rejected. So these things happens if you're not aware of the some consignment related, container related, some transaction related details. If you don't know, such disasters happens. Everything went wrong, like you're looking, you made the pre-shipment inspection, all the documentation, everything perfectly you have done, but because of your ignorance about the selection of the containers, this type of things happened. Okay. So in the container, just a minute, when you are making the container selection, at the back of this some certain informations are mentioned, some details are there in the back of the container. You should have a very clear look on it. In the container numbers are there at the, you see this is the container number, container number. This is general 7-digit number. 7 digits. First is generally they take the means alphabet, then numeric numbers. So like this 7-digit numbers will be there. Then after there is a ISO code also. The ISO code here, the last 2 digits of the ISO code, it indicates what type of container, whether G1 or G0. G1 is there is a vent is there on the G1, but G0 there is no vent at the top. So these things you have to understand. Accordingly, you have to select the consignments, I mean containers. Otherwise, you know what is disasters happened. Similarly, when we are making the consignment, then it is the responsibility as per the IMO regulations, International Maritime Organization, International Maritime Organization, as per their terms, as per their agreement, the shipper means the exporter who is making the consignment export, it is his responsibility to mention clearly the volume as well as the weight of the consignment. Both gross weight and net weight has to mention. Okay, because this is because every container has the certain carrying capacity. Every container has a certain carrying capacity. If it is exceeding, many times what happened, this shipper, this exporter, for the savings small amounts, what they do is instead of say 20 tons, he will load in 22 tons in one container. For example, it can take, say, example I'm talking, it can take say 20 tons, but he has stuffed into, somehow managed to stuff 22 tons, but the container carrying capacity is only 20 tons. So it is went to, yes, vessels like this many times happen, some incidents, because of the overweight the vessel is sink in the ocean and heavy damages are happened because of the overweight. You are declaring something and otherwise you are sending something differently. So therefore, from the time the IMO has made is mandatory, whenever you are exporting, you have to make a declaration about the weight and volume, a separate declaration to the shipping lines, your self declaration. If anything happens, many places the customs authorities also or port authorities also verifying the actual weights or volumes. If it is some cases found to be higher weight which you are declared is wrong, then it is your responsibility as an exporter, it is your risk. The consignment can be stopped in the port itself. Then all other expenses, because it will not be loaded into the vessel. So therefore, it is your responsibility to declare correct dimensions and weight. The carrying weight and other things also, generally it is mentioned at the back of it. What is the maximum weight including container? This is the mentioned here. Maximum weight including the container, that details also mentioned, so that it should not be exceeding this amount in value. If anything exceeding, it is your own risk. So on the back of the container you have to see all this detail. What is the tear weight, what is the net weight, and all these things mentioned here. Okay, so you should not at any case load material more than the maximum weight of including the container. This is the carrying capacity. Beyond it you should not stuff anything. Similarly, maximum volume that can be packed also mentioned, maximum volume also mentioned, maximum weight and maximum weight means volume. So these things you have to understand. Also, many important aspect is whether this certified container or not. Time to time there are certifying agencies are there, they certify the containers whether it is export worthy or not. I mean, suppose damaged containers are there and not export worthy, then there is chances that some damage can happen, some collapse can happen. So therefore they also have a certification. Every container has a certain certificate. They mention this certificate on the plate here, the certificate, that plate that mention the certificate details, so that is valid for it. Okay, so like this, all these details you have to see, then only you have to pick up the containers. Okay. These jobs generally we have assigned to the CHAs, means customs house agents. The customs house agents many times they also not aware of these things. They simply send the containers or some freight forwarders. They simply send, whenever you ask, you send 20 feet container standard, they can send the 20 feet standard container, but they will not see what is the other details. And loading and other things, as I told you, IMO regulations, it is the responsibility of the exporter to make the correct declaration. Otherwise, all the risk for any of the holding of the consignments or other things, also any damage also happens for that because of that misdeclaration. It is the responsibility of the exporter only. Okay. So you see there are classifications are there as per the ISO. The GO means general purpose containers without vents, and G1 means general purpose but passive vents are there at the top. Then R1 means refrigerated containers, U1 means open top containers, P1 means flat form containers, and T1 means tank containers. So like this, these are mentioned in the, you see in ISO. Here you see this in ISO declare. Here it is mentioned at the last two digits, it indicates the what I told you. Okay. Okay. This shipment related I told you. So okay. Okay. Now let us move to the some other topic. Then the certificate of origin related, some of the regulations they made recently. This is a CAROTAR 2020, means whenever you are making any import under any of the agreements like FTA, PTA, like any of the agreements, some that means partner countries, then this type of regulations we have to follow. This is about the certificate of origin related regulation. Okay. And the importer, some salient features are there. Filing of the bill of entry, preferential tariff claim, filing of the bill of entry according to the notification to claim the preferential rate of duty under any preferential comments that agreement countries, partner countries. When you are importing, the importer or his agent at the time of filing the bill of entry has to make a declaration in the bill that the imported product qualify as originating goods for the preferential rate of duty under that agreement, and produce the certificate of origin covering each item on which preferential rate of duty is claimed. This is a mandatory requirement now, and it is the obligation of the importer or his agent has to make this one declaration. Then denial by the proper officer, if the officer finds there is no proper proof or there is not submitted sufficient declaration or the certificate of origin which they are not submitted from the concerned authorities, then they can reject it. Then the onus for the further provisions is on the importer only. Then the WTO, this tariff barriers and other things, some other class I will take. Then I will explain to you the non-barriers and barriers, what is this related tariff and terms and are there, that I will tell you some other class. So with this today's lesson is we are completed. This of course I will tell you in some other class that what are the tariff related barriers and non-tariff related barriers. These barriers and other things I will tell you. What is the MFN and other thing, most favored nation tariffs, that MFN tariff and other things I'll explain to you in some other class. And today we are now going to stop this session. Any doubts are there, we can clarify. Otherwise, again, next session we'll meet.